Welcome to the Morrison Library and welcome to the Free Speech Movement Educational Programs Committee program with Dean Erwin Chemerinsky. Ooh, I hope that's not me. I want to thank you everybody for coming out this evening. We're very pleased to have Dean Chemerinsky with us here this evening. My name is Jean Ferguson and I'm chair of the Free Speech Movement Educational Programs Committee. Just to tell you a little bit about what these programs are. They're designed to engage students, faculty, staff, and visitors with the issues of the free speech movement and the wide range of activities the movement helped to inspire, including contemporary expressions of free speech, activism, and social change. We hope to inform and entertain, as well as engender debate and discussion on a wide range of topics. Our committee, our wonderful, wonderful committee, is made up of librarians and library staff here at the University Library who are passionate about free speech. And I want to make a plug that we love to work with student groups. So if there are any students in the audience who have a group or are interested in bringing a speaker to campus that has some connection to social justice or activism or free speech, we would love to work with you. So we're pleased this evening to host Dean Erwin Chemerinsky in honor of Constitution Day. So we traditionally hold a program, usually in September, but this year we've moved it to October to honor Constitution Day connected with the free speech movement. I want to make a quick plug to say that Dean Chemerinsky's book, this is not the beautiful cover copy, I'll show you the cover. The cover is right here. So his book, Free Speech on Campus, is available here in the University Library. I've checked it out right now, so I need to return it so you can come check it out. And I encourage you to do so. So I'm going to hand it over to Chancellor Christ, who's going to introduce our speaker this evening.
Thank you. I'm delighted to welcome you here tonight. Originally, we wanted to do this program in the Free Speech Cafe, but we were afraid that there were too many of you, as it turns out to be the case, to fit in the Free Speech Cafe. So we're here in this wonderful Morrison room. I am so delighted to introduce Dean Erwin Chemerinsky. He's the new dean of our UC Berkeley's Law School, and previously he was the founding dean and Distinguished Professor of Law and Raymond Pike Professor of First Amendment Law at the University of California, Irvine School of Law. He was born in 1953. He's an American lawyer and law professor. He's a prominent scholar in the United States constitutional law and federal civil procedure. As I said, he was the founding dean of the Irvine Law School, which is extraordinary. I don't think the chancellor at Irvine has yet forgiven Berkeley for our recruiting him here. Prior to assuming the position at the Irvine School of Law, he was the Alston and Byrd Professor of Law and Political Science at Duke University, and before that, he was a professor at the University of Southern California Law School, including being the Sidney M. Immis Professor of Public Interest Law, Legal Ethics, and Political Science. He's the author of 10 books, including The Case Against the Supreme Court, and 2 books published by Yale University Press in 2017, Closing the Courthouse Doors, How Your Constitutional Rights Became Unenforceable, and Free Speech on Campus, the book that you just saw the cover of. I've read it. It's a wonderful book. I really strongly recommend it to all of you. He wrote that with Howard Gillman, who is the chancellor at Irvine. He's also the author of more than 200 law review articles, and he writes a weekly column for the Sacramento Bee, a monthly columns for the ABA Journal and the Daily Journal, and frequent op-eds in newspapers across the country. He frequently argues appellate courses, including in the United States Supreme Court. It makes me feel exhausted even just to read all of that. In 2016, he was named a Fellow of the American Academy of Arts and Sciences, and in 2017, National Jurist magazine again named Dean Chemerinsky as the most influential person in legal education in the United States. That is really a big deal. And what I want to say in closing is I don't think when Erwin accepted this position, he thought that the spotlight would be on him in the extraordinary way that it is because of the issues about free speech that have arisen on this campus. I feel so lucky to have him as an expert and advisor. He has been extraordinarily generous with his intellect, with his time. He's done many programs on free speech for us, including one in Orange County just last night. We're really lucky to have him here tonight. I've heard him speak now a number of times, and you're just in for a treat. So I'm delighted to welcome Erwin Chemerinsky.
Wow. Thank you so much for that incredibly kind introduction and the really warm welcome. It's truly my honor and great pleasure to be invited to speak here tonight. And I have to tell you, I am just thrilled to be at Berkeley. I think Chancellor Christ can tell you that when she called to offer me the position on April 27th, I essentially agreed and accepted on the spot because I am so delighted to have the chance to be here. I wish the campus didn't have to go through what the last couple of months have been, but from a selfish perspective, the silver lining is that I've gotten the chance to work with Chancellor Christ much more than a new dean would usually get to work with a chancellor, and it has just been so wonderful. And tell you at the outset, I think Chancellor Christ has done a truly superb job of balancing the need to protect free speech with also the need to assure the safety of students, staff, and faculty. Let me put that statement, though, in a broader context. A year and a half ago, in the winter quarter of 2016, Chancellor Howard Gillman and I co-taught a seminar at the University of California, Irvine. It was for 15 freshmen. They were all very serious learners. They took the material with great care, reading all of the assigned material, participating in the discussions. And we began each topic by posing for the students a real-world problem and polling them as to their views. We began the first class by describing an incident that had occurred at the University of Oklahoma a year earlier in the spring of 2015. It involved a group of fraternity members who were on a bus. Only fraternity members were on this bus. They were all dressed in formal wear. Two members of the fraternity led the other fraternity members in a chant. The chant was racist. It was deeply offensive. It spoke of lynching in a praising manner. A member of the fraternity took a video of it on a phone. It quickly went viral. The president of the University of Oklahoma, David Boren, expelled the two students from school. He suspended the fraternity from operating on campus. We asked our students, to begin the first class, if the expelled students had sued the University of Oklahoma, claiming that their First Amendment rights were violated, who should prevail? The students or the university? I think Chancellor Gillman and I were both surprised that all 15 students in the class came down on the side of the university. Not one of the students was willing to speak out in favor of the free speech rights of those who've been expelled. I can tell you as a matter of First Amendment law, had the two expelled students sued, they clearly would have won in court. In fact, not long ago, I was at a program put on by the Office of Civil Rights, the Department of Education, and one of the participants was the general counsel from the University of Oklahoma. And he said that the university, including its president, knew that what they were doing was violating the First Amendment, but they felt it important to take the stand. Time and again over the course of the quarter, we saw our students coming down on the side of the university's power to punish, even severely punish, expressive activity. We were surprised that rarely did we have students in our seminar who wanted to stand up for freedom of speech. We taught the seminar again last winter. This time is a political science honors seminar to juniors and seniors. We saw the exact same thing. And we realized that what we were observing reflects a national phenomena. The Pew Institute did a survey of undergraduate students, and it came out 2 years ago, and 40% of the undergraduates surveyed believed that offensive speech on campus should be able to be punished. Chancellor Chris did a panel of faculty members on free speech here about a month ago. And it was stunning to me, and perhaps some of you were there, how many of the students and faculty in the audience, and even some of the faculty on the panel, were saying that the chancellor shouldn't invite hateful speakers or allow them to be on campus. So this is different than what we would have usually expected. I think our image of free speech on campus was so shaped by the free speech movement at Berkeley in the mid-1960s, where it was students wanting to speak on campus and the administration stopping them. Some, in major publications, have used this trend that I've just described to criticize this generation of college students. I don't share their criticism. I find the desire on the part of current college students to create an inclusive learning environment for all students to be quite laudable. This, after all, is the first generation to grow up being taught that bullying is wrong. I admire them for internalizing that message and wanting to create protections for all of those on campus. Also, you have to realize this is a generation that hasn't seen serious threats to free speech from campus administrators and the government. The anti-Vietnam War protests, or the civil rights protests of the 1960s and 1970s were as long ago for this generation of college students as World War I was for me. And to be sure, the context has changed now. As I said, the free speech movement, which is our image of speech on campus, involved students speaking and administrators trying to stop it. Now often, it's outsiders wanting to come on campus, people like, as we've had here, Milo Yiannopoulos, Ben Shapiro, Ann Coulter, and outside groups like Antifa, engaging in violence or threatening violence against them. The campus at times seems to be much more of a stage for all of this than anything else. I've now been part of many discussions of free speech on campus, here at Berkeley, as well as in other places around the country. And I think it is so important as we talk about free speech on campus to separate a discussion of what the current law is compared to what we think the law should be. I remember in the panel last month that Chancellor Chris put on, emphasizing to the audience, we can talk about what the law is, or we can talk about the law should be, but those are two quite separate conversations. Well, in our book, we especially want to focus on what the law is, though we also give our views as to what the law should be. And I really want to focus tonight on telling you what is the law with regard to free speech on campus, as we describe in this book, as it applies here in Berkeley. I want to do so briefly so we can spend most of our time together with your asking questions or making comments. I can summarize the current law for you in 3 basic points. First, all ideas and views can be expressed on a college campus. Period. Above all, the Supreme Court has said that the First Amendment means that the government never can censor speech or punish speech, create liability for speech, based on the viewpoint expressed. Under the First Amendment, there's no such thing as a false idea. Now, of course, the First Amendment applies just to the government, just like all of the rights in the Constitution apply just to the government. But there is a law in California, the Lennard law, that says that private high schools, college, universities cannot punish speech that the First Amendment would not allow to be punished by a public school. So in California, the distinction between public and private matters much less, though keeping in mind it's the First Amendment that applies in a public university like this. It's a California statute that would apply at a private school, say like Stanford. The Supreme Court, in saying that all ideas and views can be expressed, has emphasized that this includes offensive speech. In fact, even very deeply offensive speech is protected by the First Amendment. You might remember a Supreme Court case from earlier this decade. It was called Snyder versus Phelps. involved a small church out of Topeka, Kansas, the Westboro Baptist Church. They made it a practice of going to funerals of those who died in military service. They used the funerals as the place for expressing very vile anti-gay, anti-lesbian message. Matthew Snyder died as a Marine in military service in Iraq. The members of Westboro Baptist Church traveled from Kansas to Maryland, where he was going to be buried. Before the funeral, they asked police officers where they could lawfully stand. The officers pointed an area about 1,000 feet away from where the ceremony was going to take place. Before the ceremony, they chanted and sang. During the ceremony, they were silent but held up signs. That night, Matthew's father, Albert, was able to watch the news and read the signs. He was deeply offended. He was terribly upset. He sued the members of the Westboro Baptist Church for what's called intentional infliction of emotional distress and invasion of privacy. A jury awarded him $10 million in damages. But the United States Supreme Court 8-1 ruled in favor of the members of the Westboro Baptist Church. Chief Justice John Roberts wrote for the court, and he said emphatically what I said to you a moment ago. The government never can punish speech or hold it liable on the grounds it's offensive, even deeply offensive. All ideas and views can be expressed on a college campus, no matter what. Well, this leads to my second point as you understand the current law, and that's that free speech is not absolute. There are some categories of unprotected speech where the government can censor or punish. You've all heard the famous quote from Justice Oliver Wendell Holmes, where he said, "There's no right to falsely shout fire in a crowded theater." Since 1942, the Supreme Court has said the way it's going to approach the First Amendment is to have categories of speech that are unprotected. So, as you all know, child pornography is a category of unprotected speech. As you know, false and deceptive advertising is unprotected speech. The government can punish those who possess child pornography, who engage in false and deceptive advertising. There are three categories of unprotected speech that are relevant to college campuses. One is incitement of illegal activity. The Supreme Court long has said that if speech incites illegality, it then can be punished. But it's important here to separate incitement as a colloquial term we might use versus incitement as a legal term. In Brandenburg versus Ohio in 1969, the court articulated the test for when speech can be punished as incitement. The court said there has to be a substantial likelihood of imminent illegal activity, and the speech must be intended to cause imminent illegal activity. So imagine there's an angry crowd on campus, and imagine that a speaker exhorts them to go break windows, to commit acts of arson on campus. I think in that context, that speaker likely convicted of incitement. But imagine that there's an unpopular speaker coming to campus, and Antifa is going to react against that speaker. The fact that the speaker is coming to campus, even knowing the risk, wouldn't be enough for incitement unless you could show that that speaker intended to cause the illegal activity, as well as there being a substantial likelihood. It's not incitement. It's still speech protected by the First Amendment. Another category of speech that's unprotected by the First Amendment is so-called true threats. That's actually the phrase from the Supreme Court, true threats. It comes from a Supreme Court case in the 1960s, United States versus Watts. It involves a federal statute that makes it a federal crime to threaten the President of the United States. And the Supreme Court said if it's a true threat, then it can be punished. But the court said if it's just hyperbole, then it can't be punished. There isn't a lot of law from the Supreme Court defining what's a true threat. I think the best approach found in the lower courts is that it's a true threat if it causes a person to reasonably fear for imminent danger to his or her physical safety. I don't think there is a First Amendment right to cause people to reasonably fear an imminent danger to their physical safety. Imagine a student walking across campus. Imagine an angry mob surrounds that student and yells things at that student that reasonably cause him or her to feel threatened, to feel that there's going to be physical harm. That's not protected by the First Amendment. Now, I've heard some say if there's speakers in the middle of campus saying hateful things, they feel threatened by the presence of that speech. That's not going to be enough to be a true threat. Just expressing things that are hateful, it's not going to meet the Supreme Court definition of being unprotected expression. There's a third category of speech that's unprotected that's relevant here, and that's harassment. Interestingly, there aren't any Supreme Court cases dealing with harassment in the context of college universities. In fact, most of the law about speech and harassment has arisen in the workplace context. Courts have now held for decades that speech that constitutes harassment can be held liable. It's not protected by the First Amendment. The simplest example is if an employer says to an employee, "Sleep with me or you're fired," and the employee sues for sexual harassment, it's no defense for the employee to say, "But it was just words, it was just speech." The Supreme Court has held that if speech creates a hostile environment in the context of the workplace, then it can be held liable. I think the same applies in the context of college campuses. But once more, we have to separate a colloquial use of the word harassment from the legal definition of harassment. The fact that speech makes people feel uncomfortable isn't enough to make it be harassment. The lower courts have indicated, based on the employment cases, to be harassment, it generally has to be directed at a person, or at least has to be pervasive in an environment. It has to materially interfere with educational opportunities on the basis of race or sex or religion or sexual orientation. Let me compare two examples. There was an ugly incident at the University of California, San Diego, where somebody put over a tree branch what appeared to be a noose. The student who did that could not be punished for harassment. But imagine that somebody tacked what appeared to be a noose on the door in a dormitory of an African-American student. I think that surely could be punished as harassment. Undoubtedly, there's questions of where to draw the line as to when the speech becomes incitement or true threat or harassment. But that's where the questions should be asked of, well, when is it incitement? When is it a true threat? When does it constitute harassment? You'll notice one category I did not mention is unprotected speech, and that's hate speech. The Supreme Court has been clear that hate speech, racist speech, sexist speech, anti-Semitic speech, homophobic speech, is protected by the First Amendment. I do not minimize the harms that hate speech causes for those who are subjected to it. It causes enormous psychological distress. It makes those who have traditionally been underrepresented on campus feel unwelcome. I understand why some scholars, John Powell on this campus, Charles Lawrence of the University of Hawaii, Catherine McKinnon of the University of Michigan, have argued that hate speech should not be protected by the First Amendment. And as I said in my introduction, we can have a discussion over whether the Supreme Court has been right or wrong in protecting hate speech. But what you need to know is, under current law, there is no doubt that hate speech is speech protected by the First Amendment. You might remember in the late 1970s and early 1980s, the Nazi Party wanted to march through Skokie, Illinois, a predominantly Jewish suburb with a large number of Holocaust survivors. Skokie tried to exclude them, or at least tried to require them to post a large insurance bond. Every court, including the United States Supreme Court, to rule, said that the Nazis had a right to march in Skokie. Didn't matter that it was hateful, didn't matter how many people would be offended by it. There was a Supreme Court case in 1992 called RAV versus City of St. Paul. It involved a St. Paul, Minnesota ordinance that prohibited burning a cross or painting a swastika in a manner likely to anger, alarm, or cause resentment. Burning a cross, painting a swastika are vile symbols of hate. But the Supreme Court unanimously declared this ordinance unconstitutional, all 9 justices making clear that hate speech is protected speech. Why, given the harms that hate speech causes? Some of it is the difficulty of defining what's hate speech in a manner that's not unduly vague and overbroad. Any regulation of speech has to avoid the problems of vagueness and overbreadth. And yet it's so difficult to define hate speech in a manner that doesn't run afoul of these requirements. In the early 1990s, over 350 college universities adopted hate speech codes. Every court to rule on a hate speech code, without exception, declared it to be unconstitutional, almost all on vagueness and overbreadth grounds. The University of Michigan adopted a hate speech code. It followed a series of very ugly incidents on that campus. It defined hate speech as speech that stigmatized or demeaned on the basis of race, sex, or religion. What does it mean to stigmatize or demean? A sociobiology graduate student brought a lawsuit saying, I want to do research as to whether there's inherent differences between men and women. I'm afraid, based on what my research shows, I might be deemed to run afoul of that code. A federal court in Michigan declared the University of Michigan hate speech code to be unconstitutionally vague. The last 2 winners in our course, Chancellor Gillman and I asked our students to try to draft a hate speech code that wouldn't be unduly vague or overbroad. Our students found that that seemed to be an almost impossible task. Also, if you look at the experience under hate speech laws in Europe or hate speech codes in the United States, how they've been used must cause pause before supporting them. Usually they're used against the very groups that they're meant to protect. When England adopted its hate speech law, the first group to be prosecuted under it was a Zionist group, with the prosecutor claiming that Zionism was a form of racism under a United Nations declaration. Do you know who's been one of the most frequently prosecuted people under France's hate speech law? Brigitte Bardot for her animal rights activism. When the University of Michigan adopted its hate speech code, literally every request for an enforcement action under it was against African American and Latino students. But maybe most of all, the Supreme Court has said that hate speech is protected because it expresses an idea, albeit an offensive, even a vile idea. And under the First Amendment, all ideas, all views are protected. Justice John Marshall Harlan said, to censor words is to censor ideas. We can't cleanse the English language to please the most squeamish among us. My third and final point, and that's that campuses can have time, place, and manner restrictions with regard to speech, so long as they leave open adequate alternative places for communication. Even when there's a First Amendment right to use government property for speech, the government has the right to regulate when, where, how it occurs. There's no right to march down the middle of a freeway in rush hour, even though government property is generally available for speech. In the context of a campus, there can be restrictions with regard to time, place, and manner, so as to prevent disruption of campus activities, and so as to protect public safety. Campuses, for example, can ensure that when it comes to the place of speech, that it be more in open areas of the campus rather than in classroom buildings during time classes are in session. Campus can regulate the time where it goes on, prevent disruption of campus activities. But it has to still allow the speaker a reasonable opportunity to speak on campus. And campuses can have time, place, and manner restrictions so as to safeguard public safety. The campus has a legal as well as an ethical duty to ensure the safety of students, staff, and faculty. And so a campus can say, having a time, place, and manner restriction, that a particularly controversial speaker has to speak in an auditorium rather than in the middle of campus, because safety can better be protected there. A campus can restrict when the speech occurs so as to maximize the protection of safety of all. And that's, of course, what Chancellor Christ and the campus did when Ben Shapiro came, and what they've done had the Milo Yiannopoulos free speech which manifest itself. I think one of the hardest questions is, how much does the campus have to spend in order to protect public safety and still allow the speaker? Is there a point at which the campus can say, we can't ensure public safety and spend a reasonable amount of money, so we have to cancel the speaker? I think canceling a speaker on grounds of public safety should always be a last resort, which only occurs if there's no other way to assure the safety of students, staff, and faculty. But there will be such a point sometimes, and the campus's duty for safety has to be paramount. And the campus can't say, we're going to charge the speaker and the inviting student group all of the security costs if it would have the effect of preventing the speaker from coming onto campus. Skokie tried to do that with regard to the Nazis. Other governments have tried to do that. And the courts have made it clear that there can't be charges imposed on a speaker in a way that would keep the speaker from being able to appear. I've heard Chancellor Christ say that the campus has spent about $2 million already this semester so as to secure the ability to have free speech. I applaud the choice that she's made in this regard. I think it's so important that Berkeley be known as a place for free speech. But that's not sustainable. What's the point at which the campus will say, we just can't afford it anymore? Unfortunately, here, the law provides no guidance. There's no Supreme Court case on point. Lower courts haven't answered this question. The most one can say from the law is that a campus has to spend a reasonable amount of money to protect free speech. But that doesn't give very much guidance to campus officials as to where to draw the line. Now, I do want to emphasize with regard to time, place, manner restrictions I've said, that freedom of speech does not protect a right to disrupt somebody who's been invited to speak on campus. There was an incident just last Friday at the University of Oregon where the president, Michael Schill, was going to give a State of the Campus address, and a group of students engaged in speech that prevented him from being able to deliver his address. About 10 days ago, an ACLU lawyer was going to speak at William and Mary Law School, and students demonstrated so that speaker could not be heard. There was an incident, you might remember, at the University of California, Irvine, where Israeli Ambassador Michael Oren was to speak, and a group of speakers and students in turn stood up and shouted so he could not be heard. In all of these instances, I've heard it said, well, the disruptors were just engaged in speech. But freedom of speech doesn't protect the right to disrupt somebody from speaking. Otherwise, there'd really be no free speech. Otherwise, any time there's an unpopular speaker, the reaction of the audience would be enough to silence the speaker. There really would be a heckler's veto in that circumstance. There's a right to speak, but there's no right to come in my classroom and shout so I can't be heard. There's a right to speak, but there's no right to go into the Supreme Court chambers and yell so the Supreme Court can't do its business. If somebody's invited on campus, there's no right to shout so that speaker can't be heard. So these are the basic principles of the First Amendment. I've also tried to identify for you some of the gray areas. I think that above all, the premise of the First Amendment is that the best remedy for the speech we don't like is more speech. If there's hateful speech on campus, the chancellor, the deans can and should condemn it. If we don't like what's being said, we should have our counter demonstrations or teach-ins and respond with speech of our own. I know that more speech can't cure the pain of hate speech, but the premise of the First Amendment is that the only way that our speech can be protected tomorrow is to safeguard speech we don't like today. Or as Justice Oliver Reynolds also said, we don't need freedom of speech for the speech we like. We would let that go on anyway. Where we need freedom of speech for the speech we detest. So that's the thesis of Chancellor Gillman in my book, and I'd be glad for questions, be glad to have responses, comments, whatever you want, given that we have the chance to be together in this just beautiful room. Thank you.
going to say, hopefully this is it on? Okay, good. We're recording this, so I'd appreciate if all questions could be spoken into the mic.
I wonder about the kind of activities that Yiannopoulos and his confreres are engaging in. How does the university act when it knows that it's being diddled? And that's what I think is going on. For me, it complicates tremendously the discussion of speech versus the imminence of violence or the actual production of violence.
I had the sense that what Milo Yiannopoulos most wanted was to be prevented from speaking, because then he could present himself as a martyr and as a victim. And in a sense, and I'm not saying this based on anything Chancellor Christus said to me, I had the view that the campus was calling his bluff and saying, you want to have Free Speech Week? Come have Free Speech Week and protect your right to speak. And of course, that's exactly what the campus needed to. The difficulty is the First Amendment doesn't draw a distinction between the provocateur, like Milo Yiannopoulos, and the substantive speaker. It doesn't draw a distinction between somebody who's coming to campus just with the hope of being kept from speaking and one who's actually speaking. And the problem with drawing such a distinction is it would so much be a matter of perspective that when we don't like a speaker, we'll say, nah, it's just a provocateur. We don't have to allow that person to speak. And when we like to speak, we'll say, oh, that's substantive. In the eyes of the First Amendment, under the law, there's a right of all of these people to speak, even if they're provocateurs, even if they're just using the campus for a stage.
Do you think that increased penalties for hate crimes run into First Amendment issues?
No. In a case called Wisconsin versus Mitchell, 24 years ago, the Supreme Court unanimously held that enhanced penalties for hate crimes do not violate the First Amendment, even though the evidence that it's a hate crime might be the speech uttered, just like the evidence that it's sexual or racial harassment might be the speech that's uttered. A week ago today, I had the pleasure and privilege of testifying before the Senate Judiciary Committee in Sacramento, and I proposed three things to them. One is that the state legislature should appropriate funds to reimburse campus in the state for the money that they have to spend on security to facilitate free speech. That the campus are doing what the Constitution requires, but all of the taxpayers of the state should bear this cost. It shouldn't come from the educational mission. Second, there should be greater penalties for hate crimes on campus. And I think Wisconsin versus Mitchell makes clear it would not violate the First Amendment. And third, I think we need to do much more with regard to civic education, with regard to constitutional rights, including the First Amendment. I'm constantly struck by how little many people know about the Constitution. In fact, I got the great pleasure this morning in Orange County before flying back to talk to a group of high school social studies teachers about what do I think are the most important things they should teach their students about the Constitution. And I think we need to do much more of things like that. They're giving you your exercise from one end to the side to the other.
I'm struck by the example of the fraternity on the bus in Oklahoma. What if it wasn't just fraternity members on that bus? What if there were minority students on the bus also, and they were singing this song that glorified lynching? Those students might not have been in reasonably imminent fear of personal harm, but how would you treat that?
I think it becomes a much harder example, and it becomes much harder because I could imagine if you're a minority student on a bus where the white students are praising lynching, you do reasonably fear for imminent harm to your physical safety. I think in this context, where it was just the fraternity members on the bus, where it was just a video, it wouldn't meet the definition of true threat. But I think I, as a juror, might very well find under those circumstances that those minority students reasonably feared for their physical safety under the circumstances. Obviously, any court would look at the context.
Okay, thanks.
Hi, thank you. I wanted to ask, why do you find that hate speech is harder to define than other things or concepts that the Supreme Court and others struggle to define in the context of free speech, like incitement, like obscenity that was narrowed down only to child pornography and not to anything else? So like you described, the Supreme Court or others develop tests and develop parameters to define these difficult to define concepts, and you seem to single out hate as more difficult to define than others. And if I could just add another thing, I think it's worth noting that in terms of protection of free speech, the US is an outlier in terms of the broad protection of free speech, while other countries like Canada, like European countries, are more like limit other kinds of speech, not necessarily hate speech, but for example, racist speech or other more narrow concepts.
I was going to go reach for a copy of our book, and we have a few pages where we quote the hate speech laws from many other countries. And all of them are remarkable in terms of how vague the definition of hate speech is. Why do I think it's so difficult to define? Because all of these countries that have tried can never do much better than it's speech that expresses demeaning, stigmatizing on the basis of race. 350 colleges and universities tried. Every court to consider a hate speech code found it to be unconstitutionally vague. We've come up with a test for incitement, substantial likelihood of imminent illegal activity intended to cause imminent illegal activity. Nobody's been able to come up with a comparably specific definition with regard to hate speech. The Supreme Court gave up on trying to define obscenity. The last Supreme Court case to deal with the definition of obscenity was Miller versus California in 1973, because I think they found that they couldn't define what obscenity is. Child pornography is much easier to define, and that's why the court has said that it's a category unprotected by the First Amendment. Obviously, I'm crossing the line here between what is the current law and what do I think the law should be. I think the assumption of the First Amendment is a faith that we're better off with all ideas and views expressed, and that if they all get expressed, it's not going to lead to genocide, it's not going to lead to Nazism. And if those things were to happen, we're not going to prevent them by suppressing speech. Now, we can question whether that faith is misplaced, but I think that's what undergirds the First Amendment.
I've been told by one of my teachers, the GSIs last year, that the club BAMN, By Any Means Necessary, has ties to violent groups like Antifa and such as that. So I guess those specific ties, would that be still counted as protected speech, specifically under this campus?
There is no First Amendment right to engage in violence. There is never a First Amendment right to cause harm to individuals, or threats of harm to individuals, or destruction of property. Now you ask me a different question. When can people be punished for affiliating with those who might be engaging in violence? And here too, I can tell you what the law is. You can punish somebody for affiliating or being a member of a group if they actively affiliate with the group, knowing it's going to engage in illegal activity, and with the specific intent of furthering the illegal activity. So if somebody associates with Antifa and actively does so, knowing that it's going to engage in violence and with the specific intent of furthering it, they can be punished even if they don't personally engage in violence. So that's the legal test that would be applied to answer your question.
You made a reference to Nazis, and I would like to say that I think Trump is a fascist. And the people that have tried to come, including Coulter, Bannon, and Milo, are mouthpieces for that administration. And I think what happened, I'm from Revolution Books in Berkeley. I think what happened is the university rolled out the red carpet for Milo, for Ben Shapiro, and it created a situation where it was very difficult for people who wanted to protest that to protest. The police arrested people from Refuse Fascism for having a sign, which ironically was about Trump's repression of civil liberties. Our bookstore was attacked by a mob of Milo supporters after Milo's appearance, pounding on our windows, saying they were going to shut us down. We've gotten threats on the phone. People have gotten hit in the face. And this I see as a result of not only allowing but welcoming people like Milo to come. So as far as harm and harassment, I think that was carried out. And there were many people that were very upset at seeing the UC Berkeley turned into a martial law. So, I just think that Berkeley should take an example, and let me finish, and not, I think, like grease the, whatever the analogy is, for people coming that are promoting a racist, sexist, xenophobic message that is going to cause great harm and is already causing great harm to the people in this country because what Trump is doing.
Let me again go back to the distinction I drew between what the law is and what I think the law should be. Let me just talk about what the law is in this regard. And when we had the forum of faculty members convened by Chancellor Christ, several of the students and faculty expressed just what you said, that the campus shouldn't allow these kinds of hateful speakers onto campus. And finally, towards the end of that forum, I spoke as a lawyer and as a law professor. And I said, be clear as to what the law is. That if Chancellor Christ had said that Milo Yiannopoulos or Ann Coulter or Ben Shapiro was not welcome on campus, they would sue in court to get an injunction. They would win. When Auburn University not long ago tried to exclude the white supremacist Richard Spencer from speaking on campus, he went to court, he sued, and he won. He got an injunction. The campus would not only have to bear its own litigation costs, but under the law, it would have to pay Milo or Ann Coulter's or Ben Shapiro's attorney's fees. Because the law is so clear here, Chancellor Christ could have been held personally liable for money damages for violating clearly established law. The excluded speakers would have presented themselves to the world as martyrs, as victims, and they would have gotten to speak anyway. So nothing would have been gained. So I understand why you and others say the campus shouldn't welcome such speakers onto campus, but the campus has no choice. If it excludes them, it's going to get sued and it's going to lose. Now, we can then have a separate conversation. Should the law be this way? And I'm glad to have that conversation. But under current law, I don't think the criticism of the campus is appropriate because it had no choice.
Hello. How do we prevent outside groups from taking this campus hostage in a sense of shutting down free speech, besides like tremendous cost to the university? Or is that imperative to make sure free speech is allowed on this campus, regardless of ideological viewpoint?
Let me change the hypothetical a little bit and then answer your question directly. Think of the late 1960s and early 1970s when it was the anti-war protests. And the campus they want to stop it said it was outside agitators that were responsible. Or make it the early 1960s when it was the civil rights demonstrators protesting segregation. And the campus were saying it was outside agitators. In fact, they're saying it was communists that were responsible for it. What if a campus in the late 60s, early 70s said, we just can't afford the costs of allowing the anti-war protests? Or in the early 60s, a Southern university that didn't want the speech protesting segregation said, we can't afford the cost of it. I think our sensibilities would be very different in that way. Now, the direct answer to your question is, these speakers are invited by student groups, and also the campus is public property. Now, the campus can have rules for time, place, and manner restrictions in terms of how long in advance do the student groups have to issue the invitation, rules in terms of where the speech occurs. And I know that Chancellor Christ can create a commission to examine all of these rules on campus. But the campus can't exclude outsiders, especially outsiders invited by student groups under campus rules.
So I meant like groups like Antifa or right protesters that protested this lady's store. Like, how do we prevent these individuals from going on campus to shut down free speech platforms?
Well, if Antifa is coming onto campus to engage in violence, there is no First Amendment protection for its activity. But what the campus learned on February 1st was sometimes the only way to stop Antifa from coming onto campus is having a significant police presence, is having barricades. That's why Ben Shapiro was able to speak. That's why Milo Yiannopoulos was able to speak. I think that's the campus having to provide security to keep Antifa from being able to engage in violence. The campus has rules. As I understand it, there's a campus rule that you can't wear a mask as part of a demonstration on campus. I'm not sure it's constitutional under current law, but I admire the rule as a way of trying to stop Antifa and groups like it from operating on campus. But ultimately, the only answer I can think of is to make sure there's enough security that safety is protected from groups like Antifa. Violence is never protected by the Constitution.
Do safe spaces on campus run the risk of violating the First Amendment?
Sure. I think we've got to be very careful when we use the word safe spaces. It's a phrase that's much in vogue. I want to draw a distinction between three different meanings of the word safe spaces. One is the obligation of the campus to protect the physical safety of students, staff, and faculty. The campus must create safe spaces in that way. As I said in my remarks, I believe it's both a legal and an ethical duty of campuses to ensure safety. And if they can't allow speech and protect safety, safety has to be paramount. Of course, as I also said, we should only have speakers canceled on account of safety if it's a last resort and if there's no other way to assure safety. A second thing that safe spaces might mean is the protection of repose. We all need a place of repose. I think there can be much greater restrictions of speech in dormitories because that's where people live. The Supreme Court has even said there can be more restrictions of speech outside people's homes. It still has to be viewpoint neutral, but I think that restrictions of speech in dormitories will be allowed when it wouldn't be allowed in the middle of campus. A third thing that safe spaces might mean is protecting students from exposure to ideas or speech they find offensive. And that's how safe spaces is often now spoken of, that campuses should keep students from hearing speech that would offend them. They've got to make the students safe from that. Safe spaces can never mean that. We can never use the desire to create safe spaces as a justification for preventing offensive speech. Part of being in a college university should be being exposed to ideas that make us uncomfortable, even ideas that offend us. So it's that third meaning of safe spaces that seems to me completely inappropriate.
You mentioned that California has a specific law that applies essentially First Amendment protections to private schools and its institutions. What if you had, outside of California, an ostensibly private university, say like the University of Chicago? Is there some argument that it fulfills such a public place that the First Amendment should still apply to decisions made by university administrators there? And conversely, even in California, can you have an institution that has such a specific mission, such as a religious school, that there is an argument that they should be permitted to regulate speech that might be offensive to their core mission?
As to the first question, the law is clear. No, the First Amendment does not apply to private institutions, even when they're performing a public function. The leading case on this was in 1982, Rendell Baker versus Cone. It involved a private school in Massachusetts that supplied special education. It was over 99% funded by the government. A teacher criticized the principal and she got fired. Some other teachers spoke up on her behalf and they got fired too. They sued and said, given the almost 100% government funding, given that this is performing a public function, the Constitution should apply. The Supreme Court said no. The First Amendment applies just to the government. Even a private institution that performs a public function, even one almost totally subsidized by the government, doesn't have to comply with the First Amendment. Now, when it comes to private schools, there may be another source of law that protects freedom of speech, and that's that faculty and student handbooks often have assurances protecting speech by faculty and students. And there are courts that have said they constitute a contract between the school and the faculty member and the student, and so that there can't be a punishment of speech. These provisions often developed after the McCarthy era of the 1950s, where professors lost their jobs for being thought of as communists, students were expelled from doing so, and a lot of the protection of academic freedom developed in that time. The second part of your question is much more difficult, and it's something that Howard Gillman and I argued a lot about as we were writing this book. For us, the premise of academic freedom is that all ideas and views can be expressed, that it's not for the government to decide what's true and what's false, that that's really what the marketplace of ideas is. That as much as we may think that certain things are just abhorrent, we don't want to give to the government the power to say, this is abhorrent and prohibited, and this will allow. And there's a whole chapter in our book talking about the history of academic freedom. But what about a religious institution that starts in the premise, we have a truth, and we're going to proselytize this truth? Does it still have to protect freedom of speech and academic freedom? And the way this could come up is, what if a law like the Lennard law was applied to a religious school and it said, but it's part of our religious teaching that we can punish students and faculty speech if it's inconsistent with our dogma? I think that's an incredibly difficult question. I think I would still want to come down on the idea of freedom of speech, but it's not easy.
You mentioned that universities are not allowed to punish students for hateful speech. I'm wondering if there are any restrictions or if there's any lines, legal lines, as to how administrators, if they're able to comment and speak to their approval or disapproval of specific groups. Is that considered punishment? If you could speak to that.
No, it's not. And I said in closing, again, quoting from Oliver Wendell Holmes, that the best remedy for the speech we don't like is more speech. And so if there's hateful speech on campus, campus administrators can, and I believe should, speak out against it. I admire Chancellor Chris for the message to send to the community, condemning hateful expression and explaining why the First Amendment, it had to go on. I tried in the context of the law school here to send out messages, especially a message in anticipation of Free Speech Week, as well as a message at the beginning of the school year. The simple answer to your question is that government officials have free speech, and they have the right to engage it and should engage it. I mentioned being at an event put on by the Office of Civil Rights, the Department of Education, and one of the people there was the General Counsel of the University of Mississippi. And he talked eloquently about how when there's hateful incidents on campus, the campus finds it so important, the president of the University of Mississippi finds it essential to speak out against it. Now, it can't be that every time something unpleasant or offensive occurs on campus, the chancellor or university president can speak out against it. One of the things that I've discovered as a dean, that sometimes less is more. I'm going to have more effect if I speak out a little bit less. And it requires a judgment call of where to draw that line. But the bottom line answer to your question is campus officials also have free speech rights, and they can use it to proclaim the type of community we want to have and condemn the speech that's inconsistent with those community principles.
So I have two questions. Firstly, based off the First Amendment, is profane language protected?
Yes. And the key case here is one called Cohn versus California in 1969. A boy was in a courtroom in Los Angeles with a jacket on his arm, and on the back of the jacket were the words, and I apologize for the profanity, but I'm quoting, "Fuck the draft." And the boy was convicted of disturbing the peace. And the Supreme Court overturned his conviction, making clear that generally profanities are speech protected by the First Amendment. In fact, this was the case where Justice Harlan said to censor words is to censor ideas. Transgressive speech is often uniquely powerful. Think of those words on the back of his jacket. What other three words could have so powerfully conveyed the message that he was trying to get across? Fornicate the draft? There are other cases as well. There's a case called City of Houston versus Hill, where a person got convicted of swearing at a police officer. And the Supreme Court unanimously said the profanities are protected by the First Amendment. Now, again, I could imagine instances where we might come to a different conclusion based on context, but the general answer to your question, clearly established in the law, is profanities are protected speech.
All right. And the second question, are you familiar with the recent instance involving James Damore and Google?
This is the person who wrote the memo about sex differences between men and women, and Google fired him.
Yes.
Now, keep in mind that Google is a private company. So as I said in response to an earlier question, the First Amendment doesn't apply. Now, that doesn't say whether Google should or shouldn't have fired him, but the First Amendment applies only to the government. Private entities don't have to comply with the First Amendment or the Fourth Amendment or equal protection. There might be statutes that apply, but not the First Amendment.
Okay. Thank you.
You haven't said anything about libel or slander
Sure.
laws. How do they intersect? Because with the standard of reckless disregard for the truth, maybe there's a way of regulating such a reckless disregard.
I'm going to put this into the larger context of, I think the internet poses incredibly difficult issues for campus, and here the case law hasn't caught up with the technology. The internet, I think, is the most powerful medium for speech since the development of the printing press. It's democratized the ability to reach a mass audience. It used to be to reach a mass audience, you need to be rich enough to own a newspaper or get a broadcast license. Now, anyone who has a smartphone can send out something that immediately reaches a mass audience. In fact, you don't even need a smartphone. If you can go to a library that's got a modem, you can reach a mass audience. Well, now in the context of defamation, it means that defamatory speech can be circulated much more quickly to a large number of people. And defamation is simply false speech that's uttered publicly that's injurious to reputation. And the Supreme Court has said that defamatory speech is generally not protected by the First Amendment. Now, there's a whole complex set of rules in terms of when can somebody recover for defamation, and if it's a public official or a public figure, they have to show the speech was false or reckless disregard of the truth. But I really worry about the internet on campuses where false things can be said about people and circulated to a wide audience. I worry about the internet with regard to public disclosure of private facts, so-called doxing, where very private things can be revealed about information about somebody to a mass audience. The law's answer to that, well, the victim of it can sue for public disclosure of private facts. Usually that's the last thing the victim wants to do, is call more attention to the information that's been revealed. I worry about harassment of students through the internet. If you know of Yik Yak, which really seems to have been a tool just for hate and harassment of students on campus. Students getting targeted, including on this campus, faculty getting targeted for harassment over the internet. And there are a lot of studies to show that it's especially women students and students of color who've been harassed via the internet. The law just hasn't begun to keep up here with the technology. And so the bottom line answer to your question is, if it meets the test for defamation, it's not protected. There can be a lawsuit for it, but people generally don't want to sue. The real concern I have is how the internet changes all of this. especially in the context of college campuses.
You mentioned that a lot of groups that are fighting for the well-being of groups that are subjected to this hate speech and are affected negatively by it have goals that operate outside the bounds of law. Do you think it's more important that they try to accomplish these goals within what the law defines, or do you think it's more important that they work to fight to change the law so they can operate with those goals outside of that? Which would be a more productive fight, in your opinion?
I'm a lawyer, a law professor, the dean of a law school. I went to law school because I believed that law was the most powerful tool for social change. Social change seems so much more difficult today when I chose to go to law school over 40 years ago, but I still believe it's the most powerful tool for social change. I believe once people start taking the law into their own hands for the greater good, I'm not sure it's going to come out the way I want it to come out. So my answer is to encourage using legal means to bring about social change. I worry so much about illegal and violent means.
What are your views about free speech when it is not speech? In other words, laughter, like in the case where the woman laughed at Jeff Sessions during his confirmation hearing?
The Supreme Court long has held that nonverbal communication is protected by the First Amendment. There's a famous case, Tinker versus Des Moines Board of Education, that involved students wearing black armbands to protest the Vietnam War. And the Supreme Court held black armbands are speech protected by the First Amendment. There's a couple of Supreme Court cases, Texas versus Johnson, United States versus Eichmann, that held that flag burning is a form of speech protected by the First Amendment. Picketing is a form of speech protected by the First Amendment. After all, words are just symbols. There's no reason to prioritize those symbols over other symbols as a way of expressing speech. And laughter is a form of communication. I will never understand what in the world the federal prosecutor was thinking in prosecuting the woman for laughing in the midst of a hearing. She wasn't being disruptive of the hearing, as best I can tell. But yes, laughter is a form of speech protected by the First Amendment. It may be one of the best forms of speech protected by the First Amendment.
I have two questions, if that's all right.
Sure. Do them one at a time, though.
Yeah, sure. So the first one is about universities. When you mention safe spaces, I actually think there's a fourth kind of safe space, which is a place that's sort of safe for exploring ideas with sort of an implicit cultural understanding that you may say something you perhaps later regret or that's not well formed. I'm wondering whether you think universities should be that kind of safe space.
Absolutely. I hope my classroom is always a safe space in the sense that I want all my students to feel comfortable expressing all of their ideas, liberal and conservative, from any place along a continuum. And I want my classroom to be a place where all expressions of ideas are treated respectfully and we respond respectfully. So in that sense, I think that's the ideal of what a classroom should be, and then the ideal of what a university should be.
So my second question is sort of about John Stuart Mill and sort of about the First Amendment. So I personally think that on liberty is the best and most complete defense of free speech, but it's a very specific conception of what a culture of free speech is, as well as a conception of how we react to ideas and form our own ideas in response to speech. And what I wonder is, when I see the First Amendment, I see something that was written and the case law has evolved around that conception of free speech. And when that has changed, or perhaps we've changed, because I feel like we have changed, do you think that the way that we think about the First Amendment and the way it will be practiced will and should change?
I think it's a wonderful question. The assumption of John Stuart Mill is let all ideas be expressed and then responded to. The false ones will be refuted, the true ones will emerge, and the very process benefits us all. But there's lots of flaws with that. Why assume that the true ideas will triumph and the false ones will get refuted? We know that there's times when people believe things that are false. People burned witches. Does that do witches? There's times when abhorrent ideas gain hold. Think of the genocide that occurred in Nazism. And it's not really an open marketplace of ideas. Those who have money can so drown out other voices. And yet then I ask, what's the alternative to the John Stuart Mill conception of the First Amendment, knowing that it's flawed? The alternative would be to let the government decide what's true and acceptable and ban that which is false and unacceptable, and let campus officials decide who's worthy of being able to speak and who's so unacceptable to be able to be banned. And then I say, I don't want the government, and I don't want campus officials to have that power. Winston Churchill said that democracy is a bad form of government, but it's just better than anything else. Well, I think John Stuart Mill's account of the First Amendment is flawed, but it's better than anything else that I've had. And I think my conception of the First Amendment, I think a consensus has developed that we protect speech now, not because we really believe the marketplace of ideas will lead to truth, but because we're so afraid of government power as the alternative to the marketplace of ideas.
We have time for one more question.
I was curious, you've told us what the law is, and you've said, I'm telling you what the law is. Right. If you were in charge and could make the laws, what would you have? What kind of changes would you make? You talk, about this idea of why should the university bear all the costs? Maybe we need a law where this is borne by the state as a whole or something. Can you give us some other ideas where you could see some changes in the law?
I think the law is going to need to change with regard to the internet and speech. That I think we're going to need to find a way of providing more protection from harassment over the internet, more protection from public disclosure of private facts over the internet. And I would like to see the law advance in that way. I mentioned to you, I'd like to see the law develop so as to provide more penalties for hate crimes on campus. I have to tell you, I'm personally ambivalent on whether we should or shouldn't provide protection for hate speech if we could come up with a way of defining it. When I read the signs that were held up in Charlottesville, Virginia, and if you haven't read them, they were as vile and deeply offensive as one can imagine. I remember seeing one of the signs, and you can find it on the internet, that was held up, and I'm quoting here verbatim, "Kikes belong in the oven." That was like a punch to the stomach. In my ideal, should that be speech protected with the First Amendment? I don't know. I'm so afraid of government power to censor speech, and I've yet to see a hate speech law that's not unduly vague, that I think I would say that still should be protected, but I'm not sure. And that's why it's easier for me to talk about what the law is, because there's areas where I'm just not sure what the law should be. I thank you so much for your wonderful questions and for having me here tonight. It's really been a tremendous pleasure. Thank you.